Hello everyone, welcome to Lodex Assam. I'm Advocate Imdadur Rahman, and in this video, I'm going to discuss the right of an arrested person, right of a arrestee, while police officer or any investigating agency arrest a person without warrant. What are the rights of that arrested person? So today specifically, I will deal with section 47 of the bnss, which is very important section. So section 47 of the bnss, it deals with person arrested to be informed of ground of arrest and right to bail. So in subclause 1, it says that every police officer or other person arresting any person without warrant shall be forthwith communicate to him full particulars of the offence for which he is arrested or other ground for such arrest. So every person who is arrested by the police officer or any investigating agency at the time of the arrest, it is the duty of police officer to provide him the ground of arrest, the written ground of arrest. Just communicating orally is not sufficient, and the ground of arrest should be written in a way that he or she, the arrested person or the accused or the arrestee, understand in his native language. If an arrestee don't know English and you, as a police officer, communicate him, provide him written ground of arrest memo in compliance with section 47, and the accused person don't understand the language, so it is meaningless. His fundamental rights will be violated. So at the time of arrest without warrant, police officer must provide written ground of arrest, which is arrest memo in a language that arrestee understand. Mere communicating him the written ground of arrest is not sufficient. So in connection with this section 47 subclause 1, Supreme Court of India pronounced a very important landmark judgment. The name of the title of the judgment is Mihir Rajesh versus State of Maharashtra and others. In this case, Supreme Court specifically stated that at the time of arrest without warrant, a police officer must provide him written ground of arrest in a language that he or she understand. If he or she or if the police officer don't provide him written ground of arrest memo, his fundamental right enshrined under Article 21, right to life and personal liberty, and Article 22, the arbitrary arrest, to know the ground of arrest, will be violated. This constitutional right provided in as a fundamental right. So if police officer don't give the arrest memo, it's become a remedy to an arrested person to be released on bail, or his remand may be invalid. So in some cases, there is some transparency must be followed. In some situation, the offense is such heinous or such grievous or such urgent at the time of the arrest, the ground of arrest, the arrest memo cannot be provided by the police officer for urgent situation. In such cases, police officer must provide him the written ground of arrest before producing him to the magistrate prior 2 hours. So this must be followed. If the written ground is delayed, the reason for the delay must be elaborate. The written why they are delayed, this reason should be given in a application form before the magistrate. So even in urgent situation, to provide the written ground of arrest to the police officer is very essential, so that the arrestee can arrange necessary legal remedy. Hope this video will be beneficial for you. Thank you very much.